here, and thank you to all the NACDL staff for sponsoring this event. As you mentioned, this is the first of a three-part series that the Corrections Committee will be sponsoring between now and the end of April. Just by way of background, it is the mission of the Corrections Committee to advocate for safe and humane conditions in jail, prisons, and any other type of correctional facility. Additionally, the committee promotes conditions and policies that assist inmates in their reentry into society upon release. The committee is also working in conjunction with NACDL's Elizabeth Blackwood, director of the First Step Act and Compassionate Release projects. And regarding mental disabilities and corrections at both the state and federal level, we're currently reaching out to our NACDL affiliates to support us in this effort. Members of the Corrections Committee would like the support from at least 5 affiliates around the country and up to 10 members to participate in qualitative interviews so that we may gather more information about the mental disabilities and corrections, treatment and evaluation. The purpose of these interviews will be to determine the conditions and programming of inmates at the state level. This includes all mental health placement and treatment from pretrial through sentencing. In addition to the qualitative interviews regarding state and local treatment of persons or clients with mental disabilities, the committee is also sponsoring a 3-part series, and this is the first of those 3 series. The first being today, and we proudly have Elizabeth Kelly. The second is on April 20th, and it will be at the same time regarding BOP and treatment of persons with mental disabilities with Jack Donson and NACDL's very own John Albanes presenting a case study. And the third on April 27th, 2022, which will discuss advanced psychiatric directives with Lori Hallmark. Now, to our main speaker today, we are proud and privileged to have Elizabeth Kelly with us here today. She's a criminal defense lawyer with a nationwide practice focused on representing people with mental disabilities. Her family settled in Palouse country of Washington Territory in 1872, and she was born and raised in Spokane. She returned to the inland in Northwest in 2012. She co-chairs the Criminal Justice Advisory Panel of the ARC's National Center on Criminal Justice and Disability. She is the editor of Representing People with Mental Disabilities, a practical guide for criminal defense lawyers, published in 2018, and I understand there is a second edition that will be coming out soon. She also authored Representing People with Autism Spectrum Disorders, a practical guide for criminal defense lawyers in 2020. She also authored Representing People with Dementia, a practical guide for criminal defense lawyers in 2022. And she was the co-editor of Suicide and Its Impact on the Criminal Justice System in 2021, all published by the American Bar Association. She is active in the ABA, serving on the Council of Criminal Justice Section, the editorial board of Criminal Justice Magazine, the Commission on Disability Rights, and the ABA's President's Working Group on Building Trust in the American Justice System. She served as a non-governmental organizing observer on behalf of the ABA of the Military Commission hearings at Guantanamo in 2019. She also proudly served 3 terms on the board of the National Association of Criminal Defense Lawyers. She chaired its mental health as well as membership committees and is a life member. She served on the Problem Solving Courts Task Force and Body Camera Task Force, and she traveled to Liberia in 2009 and 2014 as part of a delegation sponsored by the UN Commission on Drugs and Crime and NACDL to train the country's criminal defense bar. She lectures across the United States as well as abroad on the intersection of mental disabilities in the criminal justice system. Elizabeth is the secretary of the Washington chapter of the Federal Bar Association. She serves on the editorial board of the Federal Lawyer and has regularly reviewed books for the Federal Lawyer since 2005. She served as president of the Spokane Symphony and has completed her 200 and 500-hour yoga certifications. I'm very pleased to present to you Elizabeth Kelly, who's not only a wonderful lawyer and a great author, and a welcome presenter today, but also a dear friend. Elizabeth, thank you.
Thank you so much, Pat. I'm always happy to speak before other groups of criminal defense lawyers. And in particular, I'm honored today to be the first speaker in this very, very important series that NACDL's Corrections Committee is putting forward. Vanessa, could you please put up the first slide or the second slide that's titled Mental Disabilities? Thank you. No, the next one. Yes, thank you so much. I am very, very deliberate about my terminology, and I encourage you to be so as well. The first term of which I want to unpack for you is mental disabilities. The reason why it's important to define mental disabilities and to give a precise picture is a bit like when you ask someone where they live and they say in a house. Well, that really means nothing. Do they live in an igloo, or do they live in a home which has 6,500 square feet? Do they live in a brownstone in Brooklyn, New York? Or do they live in a manufactured home in Portage County, Ohio? Do they live on the ski slopes of Aspen? Or do they have a beachfront home in Mexico? We don't know. So in other words, it's important for us as criminal defense lawyers to be precise about the mental disabilities that our clients have, whether we are talking to the prosecutor or talking to the court or talking to the warden of the facility where our client is being kept. First of all, mental disabilities is my global term for encompassing a variety of different issues. First of all, major mental illness like bipolar disorder, schizophrenia, and major depression. It also can mean intellectual or developmental disabilities, sometimes called IDD. This is, for instance, autism spectrum disorder, fetal alcohol spectrum disorder, or FASD, or what we used to call mental retardation, but we now call an intellectual disability. And finally, and perhaps most importantly, it's important to recognize that so many of our clients have co-occurring disorders. Very, very rarely do I see an individual who has a single issue, a single disability. For instance, only bipolar disorder or only autism spectrum disorder. So for instance, you can have someone on the autism spectrum, but he or she, because he or she was a bit odd growing up, maybe had some severe social and communication deficits, was made fun of by kids at school or kids in the neighborhood. He or she was bullied, and now he or she suffers from anxiety and perhaps depression. So although autism spectrum disorder may be the primary diagnosis, you could also have anxiety or depression, or perhaps a sleep disorder. So too, you can have someone with a major mental illness, and for a variety of different reasons, including but not limited to the fact that when they were released from jail or released from prison, they didn't get an adequate supply of medication or didn't have ready access to that medication. They now self-medicate. So they've got a substance abuse disorder in addition to the bipolar disorder. So what I encourage you to do is not only to be sensitive to the terminology and to understand the different nuances and the different layers of mental disabilities that your client might have, but also to be open to the fact that your client, as the years go by, can manifest different mental disabilities. So for instance, we can have a young person who was diagnosed very early with an intellectual disability, and then in late teens, early 20s, is acting out in a variety of different ways, some of which are a bit violent. What that could very well mean is that young person is beginning to show the early symptoms of schizophrenia. So you need to be open to that, and hopefully your expert is experienced and intuitive enough to sense that as well. And I'll discuss that later. Next slide, please. Thank you. Criminal defense lawyers often feel challenged by the fact that not only are they representing someone with a mental disability in the criminal justice system, that is, they are trying to fit a square peg into a round hole, but tremendously complex psychological and behavioral problems are forced to fit into certain kinds of boxes that the legal system has constructed over the years. And unfortunately, those boxes don't always fit, but nonetheless, there's room for creativity, and more importantly, there's room for powerful advocacy. The threshold issue in every criminal matter is competency to proceed. And this is a continuing inquiry, a continuing concern, and it vests from the moment of charging through the moment, as perverse as this may sound, of execution. So in other words, someone has the right to be competent at every single step of the proceeding. And this was a standard established in 1960 in the United States Supreme Court case of Dusky v. US. And it's a two-pronged test, and the accused must have a rational as well as factual understanding of the proceedings, as well as sufficient present ability to consult with lawyer with a reasonable degree of rational and understanding. And the word present ability is crucially important because you are looking at that client's competency to proceed at that moment in time. Next slide, please. Now, competency is a very, very low level. And the standard slogan is a grand jury can indict a ham sandwich. I would respectfully submit to you that a court can find a ham sandwich competent to proceed at some point in history. It's really a very, very superficial inquiry. So although many defense lawyers put forward that their client is not competent to proceed, in fact, their client very quickly is going to be found competent if he or she is, and again, this depends upon the nature of the disability, is given the proper medications, is given some degree of structure, is taught via classes what the role of a judge is, what the role of a jury is, what the role of his or her attorney is, what the difference between a plea and what the difference and going to trial is. It's very, very superficial. But I encourage criminal defense lawyers to play the situation out, or maybe be careful what you ask for. Because again, this is so contingent upon the nature of the disability. If you have someone with an intellectual disability, someone who is diagnosed at a young age with an intellectual disability, has an IQ, and for years has continued to test at that particular score, the baseline is, if you will, what the baseline is. Now, it could very well be that through very targeted counseling, through targeted therapy, your client might acquire some life skills, some skills for better executive functioning. But again, the baseline is what the baseline is. He or she can never be restored to full competency because it's a very, very low threshold. On the other hand, you can have someone with a major mental illness, and depending upon the nature of that mental illness, how persistent it is, the damage that has been done to the brain, that particular client, by virtue of the right medication in the right dosages and the proper support systems like housing, transportation, perhaps employment, if he or she is capable of holding a job, can be restored. The challenge is keeping that person restored. So for instance, if someone is quote unquote restored at the state facility and then is sent back to the county jail and has to wait days or weeks to get back into court to be declared competent, and during that time back in county jail is not getting the proper medications in the proper dosages, he or she is quickly going to decompensate, and it's going to become a revolving door. By the same token, you as the criminal defense lawyer may want to do a very, very careful calculation as to what it's going to take for your client to be assessed, particularly if your client is in custody, how long the waiting period is going to be, and what the conditions are going to be. And sad to say, throughout this country, despite orders from courts, including federal courts, about a certain time period when a client, when the accused must get a competency evaluation, we have people waiting days, weeks, even months to get a bed, to be assessed, to be seen by a doctor, to be assessed. Outpatient evaluations are a bit of a different situation. In an outpatient restoration is a bit of a different situation. But you need to play the situation out based on the nature of the disability and your disabilities, based on the jurisdiction, based on the level of charges, and based, unfortunately, on the access to resources. So for instance, if you are representing a client with dementia, restoration is a fictional concept. At most, you can manage the symptoms, but in point of fact, those symptoms are only going to get worse as the disease progresses. Next slide, Vanessa. Now, just as competency to proceed was a low standard, responsibility or insanity at the time of the act is a very high threshold. And just as competency to proceed looked into the client's present capacity to understand the nature of the proceedings, responsibility or insanity at the time of the act is a snapshot, hence the camera at the bottom, of your client's capacity at the time of the alleged act. Now, contrary to popular belief, criminal defense lawyers are not willy-nilly entering pleas of insane at the time of the act. In fact, this affirmative defense is only put forward in a small percentage of the cases for a number of different reasons. First of all, as I said before, it's an extremely high standard to meet, depending upon what jurisdiction what definition of insanity your jurisdiction has adopted. Beyond that, it is often very difficult to get a precise picture of your client's ability to function at the time of the alleged act. So for instance, if your client allegedly committed the act and then was arrested 6 months later, it's going to be very, very possible, very, very difficult for your forensic psychologist or psychiatrist to get an accurate picture of your client 6 months earlier. It can be done, but it's going to be much more difficult. So too, it's going to be difficult if you as the attorney have not had an opportunity to meet your client for some time after the alleged offense, or you've just been retained. The best evaluations, the most potent evaluations are conducted when your client is actively psychotic and your experts can get a very, very accurate picture of your client at that point in time. And then another reason why insanity defenses are put forward so infrequently is, again, criminal defense lawyers play out what can happen. And in some situations, it may make sense to, depending upon what the offense is and what the plea offer is, to take that plea because you have a relatively good idea of what the sentence, what the term of incarceration is going to be. Whereas if someone is found insane at the time of the act, he or she is going to be institutionalized in some fashion, and you don't know what the out date is going to be. Next slide, Vanessa. Thank you. And here I have reproduced the federal insanity statute, and you'll notice under B, under burden of proof, the defendant has the burden of proving insanity by clear and convincing evidence. Next slide, please. So if your client does not meet, or if incompetent to proceed is not going to be the best outcome for your client. If your client can't meet the very high standard of insane at the time of the act, there are still some options for you. And depending upon the power of your expert's evaluation, and I'll talk more about that later, you can use the mental disability in a variety of different reasons. You can use it as mitigation, or you can use it to leverage a plea, or again, what you might be able to do depending upon the language and the tenor of that evaluation is use it to negate or blunt the mens rea of the offense charged. And I also should add that in many, many jurisdictions, there are strong and robust mental health courts or behavioral health courts or veterans courts, and those might be an option. But for here, I'm just addressing traditional courts as we know them. So if you use the mental disability as a tool to leverage the plea, you may very well want to bring your expert in on the discussion with the assistant U.S. attorney, with the prosecutor. And you also will want to use that report and your expert at the time of sentencing to use the disability. Now, all too often I hear from parents that they have been told by their current attorney that the mental disability does not matter. Yes, it does matter. It is who your client is. It is an inextricable part of their identity. And if the case is properly worked up, it can be used. It may not be powerful enough to get the charges dismissed entirely. There may still, unfortunately, be a period of probationary supervision or a period of incarceration, but you can use that ability to argue for a better plea offer or for a better sentence, a sentence that is not going to subject your client to as many of the harsh realities of prisons as he or she might otherwise face, and I'll discuss that more later. Or you can get a probationary sentence, a supervisory sentence that is both going to keep the community safe, something that is going to appease the court as well as the prosecutor, as well as prevent your client from reoffending and getting in trouble again. And one of the reasons, quite frankly, that so many of these cases involving people with mental disabilities result in mitigation if incompetency to proceed is not successful or desired, and if they are found sane at the time of the act, is that the trial penalty is just so onerous that it makes sense to plead guilty and to powerfully advocate. One more practice point before we advance to the next slide. You, as the criminal defense lawyer, are not using the mental disability as an excuse, but rather you are using it as a reason. So for instance, if your client has a developmental disability, you can successfully argue with the assistance, hopefully, of a good forensic report that your client was uniquely vulnerable to social pressure, and that's why he or she may have committed the offense in question. Next slide, please. You cannot go forward, in my belief, with representing someone with a mental disability unless you have a top-notch expert or experts. And just like in every profession, there are some people who are very, very good, and there are people who are not so good. So too, in the field of forensic experts, there are some people who are stronger than others. And if you will pardon me for one moment, my slide is cut off, so I'm going to go to my master list. First of all, in terms of the expert or experts, define why you want an expert. And all of these bullet points under the expert necessarily bleed one into the other. If your client is currently in counseling, is currently being treated by a clinical psychiatrist or psychologist, or perhaps a social worker, that is wonderful. That is important. And if there is good chemistry, he or she should be encouraged to maintain that. But on the other hand, the treating doctor cannot be the independent forensic expert. And independent is key here, because although you as the defense attorney are going to request an individual, although you are going to retain a particular individual, any expert worth his or her salt is going to guard very, very fiercely his or her professional independence. And yes, there are some experts out there who have a reputation for, and even a mission to serving as experts only for the defense or only for the government. Nonetheless, he or she does not want to compromise his or her integrity, and he or she does not want the reputation as a hired gun. So although your independent expert is probably going to contact the treating expert and find out what the course of counseling is, and if he or she has been, or that is to say, if the accused has been compliant and shown improvement, your forensic expert is not going to rely only on the word of the treating expert. I'll talk later on about some of the other sources of information your expert is going to rely upon. But for purposes of conflict of interest as well, you cannot have the treating expert be the independent evaluator. You want to define early in the process why you want your expert. And in some sense, it may be too early for you to know what you want, or in other words, you may not know what you may not know. But And we can talk more during the question and answer period if you like about how you know your client has mental issues if you don't have a prior diagnosis. But nonetheless, when you see the red flags and you contact someone and you describe the red flags, your expert can get on board early. And you could very well say in the beginning, I don't know that he's competent. I can't seem to get through to him. And you could also say that you need your expert to help you with communicating to the client, how to present the pros and the cons of going to trial versus taking a plea offer, how to make the accused understand that if he or she is a sovereign citizen, that type of defense is not going to be, or that type of argument is not going to be persuasive with the court. And again, you should be open to the fact that the role of your expert could very well change and evolve during the course of the representation. You may want to know where to find the expert. And since this is an NACDL sponsored webinar, I should say that one of the best sources of referrals is going to be one of NACDL's many listservs. But when you are asking for a referral, whether it's through NACDL or in conversation with a trusted colleague, please don't just say, I need an expert. Have an idea why you want an expert. Is it for competency? Is it for sanity? Is it for mitigation? Is it for general help dealing with the client? And then if you have an idea of the diagnosis or the diagnoses, that is crucially important. So for instance, if you are representing someone with dementia, you are contacted by their family, then you want an expert who is not necessarily a generalist, but who has a particular expertise in dementia. And if he or she is a forensic psychologist, can administer the appropriate tests, but also knows that neuroimaging will be important. So he or she can recommend a good neuropsychologist or neuropsychiatrist to do the neuroimaging and to help you utilize that. So too, if you're representing someone on the autism spectrum, it could be that your client has been diagnosed or was diagnosed many years ago, and his or her family has boxes of written evaluations. So you know that you need an expert in autism spectrum disorders, someone who is published in that field, someone who has lectured in that field, someone who understands the nuances of that particular issue, and someone who is also in a position to recommend other experts if need be. And then a final caveat that I want to give. We are, God willing, wrapping up the global pandemic, but the mental health or the field of mental health experts has been inalterably changed. And getting highly qualified forensic psychologists, forensic psychiatrists is extremely difficult, in large part because these individuals are busy with their own clinical practice. More and more doctors are now seeing patients in person. More and more doctors are now able to get into the jails and the prisons. More and more courts are opening up for formal in-person proceedings, and people are busy. So what I would recommend you do, if you are in a position to pick your expert, have a very frank conversation with your expert. When will your expert have time to meet with the client? When will your expert have time to conduct all of the collateral interviews and review proper documentation and write an extremely thorough evaluation? If he or she cannot do it for 6 to 9 months and your client is in custody, that needs to be established. And you need to decide whether or not that's an obstacle, and you need to seek someone else. And also, I should add that when you're looking for an expert, not only do you want a glowing recommendation from a colleague, not only do you want a sterling resume, but you want to make sure that that expert is available to you, that your expert can respond to your phone calls and your emails in a timely fashion and is happy to be part of your team in whatever capacity. So next slide, Vanessa, please. Actually, if you just want to whip through this slide labeled Table 1 and the next slide labeled Table 2. This is a graph which I wish I had created myself, but instead it was assembled by Dr. Jonathan DeWright, who is a superb forensic and clinical psychiatrist in the Maryland, Virginia area, who specializes in dementia. And the two graphs discuss not only the differences between the different kinds of mental health experts that you would want to assemble for your team, but also gives a list of do's and don'ts for working with these experts. So I commend these two graphs to you. Next graph, or next slide, please, Vanessa. So now that you have retained or your court appointed expert is on board, let's talk about the evaluation and how your expert can put together the most helpful evaluation possible. First of all, interviews with the client. And I stress the plural of interviews because your expert needs to have a series of interviews with your client, not only so he or she can better understand your client, but so your expert can see the evolution of your client's behaviors, and also build a bond of trust. You may have very well seen what we derisively call drive-by evaluations conducted by the prosecutor or the government's experts. And more often than not, these are called drive-bys, not only because they're very terse and they don't have a lot of depth, but also they're based on a very, very brief single interview with your client. And you don't want that to happen. Your client deserves more. Any expert with his or her salt conducts multiple collateral interviews with family, friends, neighbors, co-workers, people with whom he or she has served in the military, anyone who can give a good picture of your client, a good long-term interview of your client, or estimation of your client. And you want this for different reasons, again, depending upon the nature of the disability or the disabilities. So for instance, if this is your client's first offense, and your client is perhaps of a certain age where he or she would not have been screened in schools or had teachers in schools who were attuned to autism spectrum disorder, and your client was not diagnosed at a young age, and now you've got an expert who opines that your client does have autism spectrum disorder. You do not want the prosecutor and or the court to say that this diagnosis was just manufactured at the 11th hour for purposes of the criminal case. Rather, you want family, you want teachers, you want neighbors and friends to say, look, he has always been like this. He has always had sensory issues. He has always had difficulty communicating. He's always been the odd person in the neighborhood. We always knew there was something a bit wrong with him, but we never knew what it was. So too, you could be representing someone who's been in trouble again and again and again, but prior counsel has not put forward that the client has a mental disability or mental disabilities. You want the collateral interviews to support that, yes, this person has always been like this. Unfortunately, for whatever reason, mental disabilities have never come to the attention of the court. By the same token, you could be representing a veteran who suffered a traumatic brain injury and now is acting out and has been charged with a particularly violent offense. You will want your expert to be able to interview people with a theme of before and after. That is to say, he or she was like this before, he or she conducted him or herself in such a way before deployment, but after he or she returned, after the injury, he or she was an entirely different person. Another thing you want your expert to do is to conduct a thorough review of all the documentation. And by that, I mean not only educational records and any medical records, but also document review means review the discovery that you have provided. The last thing you want the government or the prosecutor to point out in their response or their reply brief is that your expert did not review the discovery. And if your expert or did not review certain items of the discovery, And you do not also want that pointed out during the course of cross-examination at a hearing if your expert testifies. Sometimes, if your expert had known about that particular piece of evidence, your expert's opinion might have changed, or your expert's opinion might not have changed, but your expert could explain that on the face of it, it's not as significant, it's not as detrimental as the government, as the prosecutor would lead people to believe. If nothing else, you never want your expert to feel blindsided. Also, your evaluation, depending upon the nature of the disability, will want to contain testing. Your particular expert, for instance, if your expert is a psychiatrist, may not be able to conduct a lot of testing or the particular testing required. Again, depending upon the nature of the disability, that may be and the nature of your expert, that may be the bulk of your expert's work. But nonetheless, your evaluation should incorporate the testing. And the testing should be a part of the entire piece, the entire picture of your client. So for instance, if you present neuroimaging to the court, that neuroimaging itself is not dispositive. That neuroimaging is in itself not a diagnosis, but nonetheless, the very graphic image of pictures of your client's brain can show to the court that there's a reason why your client conducted himself in or herself in such a way, and that in conjunction with the interview of the client, the collateral interviews, and the document review makes it all make sense. And I should also make note of the fact that many of our clients, no matter what their specific disability is, are younger. That is to say, they are in their early 20s. And because of that, although in the eyes of the law, they are adults, their brains are still forming. This is science. These are the facts that Roper and Miller and Graham were built upon. And your forensic expert should address the fact that although, for instance, autism spectrum disorder or bipolar disorder or FASD may be the primary diagnosis, the fact that your client is in his or her early 20s and he or she is still in the formative stages should be addressed and is important. Next slide, please. Thank you. Jail or prison conditions. The worst place in the world for any of our clients with disabilities are jails or prisons. And it is shameful in this country that we have basically criminalized mental disabilities, and we are punishing people for manifesting the symptoms of their disabilities and what is essentially a public health program has moved to the criminal justice system. But unfortunately, our clients are now in that particular system, And if there's not a creative way of diverting them out, if depending upon the jurisdiction and the nature of the offense charged, you are unable to divert them into a mental health court or a veterans court or some other problem-solving court, we're dealt the hand, we have to play the hand that we are dealt with. If the case is pending, and again, depending upon the nature of the charges and the nature of the facility, please, please get your client out on bond, because jail can be absolute torture for a defendant with a mental disability, for the same reasons that prisons can be torture. What you can argue to the court, whether you are arguing for bond or whether you are arguing for mitigation of a custodial sentence, is quite frankly the cost. These are expensive people to house because of medication, because of other special medical needs. In the case of an older client, a client with dementia or other age-related issues, he or she needs other care, and it's expensive. Then again, depending upon the nature of the disability, your client is going to be victimized. If your client, for instance, is on the autism spectrum, and he or she has just some really, really weird social mannerisms, maybe tics, maybe stims, maybe rocks back and forth. Maybe if he or she is paranoid schizophrenic, and hears voices and talks to voices, he or she is going to be called crazy by the other clients, by the other inmates, and or made fun of. If your client has an intellectual disability, and coupled with the fact is very, very small of stature, he or she is going to get picked upon by the other people in the facility. He or she is going to get talked out of commissary funds, or he or she is going to get forced into asking their family for additional money that he or she is going to have to give one of the other inmates, or he or she is just going to be the victim of other forms of emotional or physical abuse. Your client may be fundamentally unable, no, not that slide, the jail and prison conditions. He or she may be fundamentally unable to follow the rules of the particular facility. So for instance, he or she just is not able to appear for count. He or she is always asking why, and doesn't understand that the CO is in charge. He or she may move rather slowly. He or she may, for whatever reason, just not understand that this is a regimented and hierarchical environment. He or she is going to get punished, is going to have privileges taken away, or worse of all alternatives, he or she is going to be put into solitary for a prolonged period of time. Your client can also be disruptive. So for instance, if you have an elderly client with dementia, he or she may be unable to attend to personal hygiene, whether it's changing their own sheets in their bunk or not being able to attend to toileting needs. This is going to make him or her very, very unpopular with the fellow inmates, particularly in closed and confined quarters. your expert in the course of his or her evaluation should address this insofar as possible. And again, draw a nexus between the nature of the disability and the type of a facility. So for instance, if your client is on the autism spectrum and has severe sensory issues, that is to say, the bright lights, which are on 24/7, the banging of bars, the yelling of the other inmates, this is going to be absolute torture for your client, and your expert should address this. And it may very well be that you need to bring on board another highly reputable prison consultant who can talk about that. Not only is the facility unable to provide the support services that your client needs, but your client is going to be tremendously ill-served by the prison environment. If you, as the criminal defense lawyer, are in a position to argue for something less than, if you are in the position to argue for something less, you need to show the court the path forward, because there are many judges out there, there are even some prosecutors out there who are very sympathetic towards our clients and their disability, but either they're elected or they're constrained by the sentencing scheme. And we need to show the court the path forward, how our client can be successful in a place short of prison or in a term less than what the court is originally inclined to impose. So we need to show alternative facilities, or we need to show how in the community our client can be productive and law-abiding. That is to say, where he or she is going to live, how he or she is going to be supervised. If it is a computer-related offense, how he or she will have his or her access monitored or curtailed, how he or she is going to get medication, how he or she is going to be transported, what type of therapy, what type of counseling, basically all of the things that are going to show the court that this person is being supervised 24 hours a day. And if the supports are provided, your client will take advantage of this second chance and not be before the court again. Next slide, please, Vanessa. Now, when Jack Donson speaks to you, he is going to probably tell you about a number of different fine programs within the BOP. And in your sentencing memorandum, you may very well want to ask for one of these facilities if in fact a prison sentence is inevitable. But state facilities also may have particular kinds of programs. And depending upon your jurisdiction, you may want to investigate these programs and you may want to make a specific request. But I list these programs for a couple of different reasons. First of all, to familiarize you with them. But secondly, to state that they have their limitations. Some of these programs only take a very, very small amount of people. So for instance, there is a relatively new memory care unit at Devon's in Connecticut. Unfortunately, it only takes 35 people. There is no way, no how, particularly given the aging prison population, that is suitable to service the entire Bureau of Prisons. So too, these other programs are limited in terms of the numbers of people they can take. Beyond that, they are limited, or they have different eligibility requirements. So for instance, you in your sentencing memorandum could talk about the scarcity of resources. And then the government in its reply could say, oh no, Your Honor, there is a multitude of programs within the BOP, and here they are. But take a very careful look at that laundry list, because it could be that some of those programs only help people who are convicted of sexually oriented offenses or crimes of violence, or who are of a certain age. And that is not at all appropriate for your client. Next slide, please. Thank you. And the next couple slides are cases of about compassionate release that I very, very briefly wanted to review with you. And I should give a huge shout out to a number of individuals who helped compile this list. First of all, NACDL's own Elizabeth Blackwood. Secondly, Dr. Mark Blasting. And finally, the law firm of Levitt and Kaiser in New York City. And for those of you who read the daily Compassionate Release blog, the firm of Levitt and Kaiser are the ones who every day give you that data. There have been a number of cases, particularly during the rise of COVID, where in addition to arguing about the horrible atmosphere in our federal prisons that COVID creates, but also argue that because of the clients, the accused, particular vulnerabilities because of mental disabilities would be vulnerable in the Bureau of Prisons. And compassionate release could be a very, very powerful tool for getting our clients with disabilities relief. And in some jurisdictions, there are also second look vehicles, second look provisions that could be important for getting our clients out. One of the things I encourage you to do is go to the sentencing transcripts. And if your client's mental disabilities were argued at the time of sentencing, but your judge, for whatever reason, felt compelled to impose a custodial sentence and put on the record that he or she felt badly, this is a good time to come back to court. If you had an evaluation or prior evaluation that said, if this individual goes to prison, he or she is going to be victimized in the following ways, and then you have that same expert or another expert go back and interview your client in the institution and do an update of that report, that expert can basically come back with a report whose theme is, we told you so, and it all happened. And in some respects, it was worse than we originally thought. And a number of the cases in this slide as well as the next slide. Can you pop that up, Vanessa? Do a good job of discussing not only the mental disability, but how that particular mental disability makes that person even more vulnerable, certainly during the time of COVID or post-COVID. So I commend these cases to you, particularly if your client looks like the situation is congruent with the ones listed here. And I think we are probably at the end of the of this this presentation. I'm happy to answer any questions that you might have now. Vanessa, could you bring up the next slide? Yes, the shout outs. And the final slide. If you don't have a question now, you are welcome to contact me in the days or weeks or even months following this presentation. I'm happy to answer questions, and I'm certainly always happy to brainstorm with other defense attorneys. So, Pat, do we have any questions?
I'm not seeing any, but a couple, can you all hear me? A couple of things I wanted to point out. Shuli Carroll has been posting in the chat. First of all, she posted your link and your email address again. In addition, she also posted the upcoming events that we have planned. And she posted, if people want to provide information regarding what's going on in their jurisdiction to the National Association of Criminal Defense Lawyers, they can do that through Vanessa Antoon. They could contact her, or in addition, as you may all know, we last year had posted an interactive map regarding prison jail communications. And there is a form that you can complete on that map. Shuli's posting it again. So I just wanted to point that out. I don't see any additional.
I have a question.
All right.
Yes.
Who asked that?
This is Amelia Swanson from Montana.
Hi, Amelia.
Hi, thank you so much. It's been a wonderful presentation. I started doing some federal mental health, a lot of drug cases. A lot of a guy said to me one time, and I'm gonna, please don't take offense, you said the correct word, intellectual disabilities, but it used to be mental retardation. And he said to me, and I was a young lawyer, and he said, how come you get all the retards? And I thought about it. I know, but he didn't mean it cruelly. He's long died. He was a Led Zeppelin addict, alcoholic, very good criminal defense lawyer. He just was rough around the edges. Anyway, I got a lot of clients that were the small fish in the drug world, while the big fish all got away. And they, a lot of them, I mind those cases. I was young and ambitious, and now I'm old and tired. But
you're experienced. You're experienced.
I'm experienced, but it's just gotten so heavy. For one thing, I'm doing a lot of OPD work now as a contract attorney, and they're shorthanded, and people are just floundering. They're overwhelmed. Everybody's overwhelmed, and everybody's getting overcharged. And it's so, and what you said, I really appreciate what you said about finding an expert who interviews the family, the football coach, the priest, minister, the major in the army, whatever. I mean, I'm not criticizing the expert I've had, but kind of I am, because I know these. First of all, my sister had schizophrenia. She died during COVID. She was my older sister. I've been exposed to mental illness or people with mental illness since I was a baby. She was 6 years older. And honestly, I worked as a mental health advocate for years, and I volunteered my time as a young adult for intellectually disabled people in Bozeman, Montana. I used to do fundraisers, and I had a client. It was like a big brother sister program. but you had a intellectually disabled client. My guy had Down syndrome. And so we go to rodeos. I was just his friend. We go bowling, we go to lunch, but I've always been involved in mental health, and now I'm still involved, but I've got a big case coming up now. I've had like so many clients with mental illness and so few experts. And
And you're in Montana too. Yeah, yeah.
Yeah, and I mean,
It's particularly hard in more remote areas. And during the time of pandemic, I still have a client who is in a state which did not recognize the pandemic and did not have a lot of policies and protocols in place or that were being followed. And because of that, I had a very, very difficult time getting experts to come into the area.
I really, yeah, I'm having a hard time. I mean, I want to use a local expert, but the one that is actually attached that I can get funding for, because my clients are indigent, most of them now are indigent. I'm finding that I'm real limited, and I was a lot more creative when I was younger too. I remember sitting in a when I was doing federal work, I went to the federal prosecutor's mental health expert, sat in his office, I said, I'll just catch him in between clients. I only need 2 minutes. And I had the federal statute in my hands. And
Good.
it was a mitigating statute. It was a 5K 2.13. You take away the drugs and alcohol. What do you got left? If they're basically mentally ill, you can get them out of the guidelines, and the judge can do whatever they want pretty much as far as sentencing. So they don't really have that in federal court, do they, as far as a mental defense?
Good.
For trial?
Listening to this training.
Well, it depends upon the nature of the disability. Obviously, you've got insanity as an affirmative defense. Again, depending upon the nature of the disability, you can use that to negate the mens rea. But you should do the calculation in terms of what would happen if your client goes to trial and loses, versus a really powerful report that might cause the government to extend a relatively reasonable plea offer and or give you the room to argue for a variance or a departure. But again, it all depends on the nature of the charges. In terms of the local expert, what you might be able to do is argue to the court that, Your Honor, this is the only person available in our locality. And because of that, he or she is incredibly busy. He or she cannot see my client for the next X number of weeks or months. We know Your Honor wants to move this case. And I have identified an expert from Casper or Minneapolis or Chicago or Bismarck, or even Spokane, who can come in next week. But the funds are going to be need to be available in order to compensate that expert, and then file your AIC motion or whatever would be most appropriate.
So we have another question here from John Albanes. He said, first of all, thank you for the presentation. How do you handle clients who you believe may be suicidal but are not completely certain? For example, they write you a letter talking about ending it all. What if you know that if you disclose your concerns to officials, the client will be placed in solitary confinement, a place the client has told you they have hated? So.
Yeah. That is an extremely fraught issue. And as John identified, there are a host of ethical issues which are part of that question. Right off the bat, I would say the attorney has to ask his or herself, who is this client? And does the client have a history of doing this? It took me a long time to figure this out, but just because a client has a mental disability does not mean they are not capable of being manipulative. So your client could, if you will, just be crying wolf. That is to say, you are going to feel horrible, to put it mildly, if in fact your client is serious. So my recommendation would be to get your expert in there and meet with the client and get a sense as to how sincere this is, and go from there. The problem, the challenge that we all have is we're quote unquote just attorneys. We're not doctors, and we have not only our own ethical constraints, but we have the limitations of our education and our experience. But it could also be that, depending upon the facility, there is a way of resolving the situation short of solitary, and it might be through proper medication, or it might be that a transfer to a different facility could be something. But thank you for the question, John.
So Penny Strong from Montana, how do you recommend proceeding in states where the legislature has effectively eliminated the not guilty by reason of mental disease or defect offense?
Yeah. There are a few states, primarily in the West, that don't have an NGRI option, and not guilty by reason of insanity. And for those of you who are interested in this issue, I commend the Kahler decision, Kahler, which came out right before the pandemic and was authored by Justice Kagan. And she basically says there is no constitutional right to an insanity defense if the accused has the ability to put the mental disability in play, to argue it, and in particular, to use it to negate mens rea. A big fear on the part of the criminal defense bar was that the Kahler decision was going to cause the more conservative or less criminal justice friendly jurisdictions to repeal the insanity statutes that they had on the book. One of the few perverse silver linings of the pandemic was that it stopped that, and legislatures, quite frankly, had other things to worry about and consume themselves with. But it's a well-founded fear. Again, Penny, it goes back to, and I've said this 400 times during the course of this webinar, I apologize. It depends upon the nature of the disability. It depends upon the nature of the charges, and it depends on the jurisdiction. So you plot in all of those variables and try and figure out as best you can what makes sense in terms of going to trial versus getting a barn burner of an evaluation that you can use either to leverage a really good plea or for substantial mitigation at the time of the sentencing. And if you can't, Penny, if you've got a specific case that you want to brainstorm about, I'm happy to do that later offline.
So I just want to add one thing, Elizabeth. One of the things we have learned in preparing for these qualitative interviews with different affiliates is that these departments of mental health are created by statute. And the reason that they're there is to churn these cases through, and their evaluations, as you mentioned, are often very cursory.
They're drive-bys.
Right, which is why it's important for us to get our own expert and counter their evaluations and even point out how shoddy the evaluation is.
And if I could add to that, if in fact you are in a position to retain your own expert, in most situations, you have the ability to control how that evaluation is used, or even if it's written up, or even if it's shared. So for instance, if your doctor goes into the jail, meets with your client, maybe does some testing, and then makes a courtesy call and says, look, you do not want me to write your report. Your client's faking it. He's as competent as you or I are. Then you could thank him or her very much for the phone call, and no one needs to know that your expert went into to the facility or interviewed your client. By the same token, you could get a report that you don't like, depending upon the jurisdiction and depending upon the resources. You can get a second evaluation that is more complete, that perhaps consulted all of the pieces of collateral information that that the prior expert did not consult.
Yeah. One final thing I will say, and you mentioned this, and I say this because you were on the body worn camera task force while you were on the board of NACDL. You can get a lot of information from a body worn camera video about your client's state of mind at the time of an offense. I just wanted to point that out.
Yeah, yeah. And also when you're reviewing the body camera image, and your mental health expert is going to talk to you about this. States of mental disability are fluid. So for instance, your client could appear mentally ill in some, and in others appear perfectly normal. And you should be sensitive to that. The same with the issue of malingering. Your client may be malingering as to some symptoms, but the presentation as to other symptoms could be completely genuine and completely valid.
Thank you so much, Elizabeth. I don't see any other questions, but we could probably go on for a couple of hours here.
You don't want me to do that.
We look forward to your second edition of your book, and can't thank you enough for this presentation. I don't know if Vanessa has any closing statements, but we look forward to talking with you in the future and reading your book, as well as having you participate with our committee. And we look forward to our next in the series of presentations next Wednesday. And I'll turn it over to Vanessa. And thank you everyone for this opportunity to present this. It's invaluable.
Thank you.